Solid waste management in Indian country comes with its own and various issues. The primary issues seen are jurisdictional issues, dealing with counties and states, and the checkerboard status of tribal lands. Likewise, tribes must deal with the domestic dependent sovereignty status and the issues that go around regarding enforcement of laws and other jurisdictional issues. The second issue is an enforcement issues. This usually relates to the virtual inability to prosecute non-Indians and the generally high ratio of acreage to be managed to the number of tribal personnel. The third main issue is cultural issues, including traditional dumping patterns that are no longer appropriate with modern waste. A fourth issue are social issues. This relates to beliefs of common ownership and victimization, as well as differences in ideologies between some tribal members and some non-Indian neighbors. The fifth issue, quite often seen in Indian country, is funding. Because of tribes' unique status, tribes have different ability to access federal funds to enforce environmental statutes. Likewise, tribal ideologies affect the tribe's ability and/or willingness to tax reservation residents, as well as the ability to collect fees from non-member residents who might utilize a tribe's solid waste management program. A sixth common issue is infrastructural issues. This has to do with the institutional inexperience, administrative structure, including federal agency involvement, and the role of traditional and bureaucratic authority figures. Likewise, infrastructural issues may include road issues, buildings, and the ability to build new solid waste facilities. The seventh main issue often seen is internal tribal issues, dealing with coordination and collaboration between tribal departments, as well as interactions with tribal decision makers, such as tribal councils and governing boards. Addressing these issues starts with an understanding of the requirements to comply with federal environmental statutes. RCRA clearly prohibits open dumping. In addition to RCRA, there is also the Indian Lands Open Dump Cleanup Act of 1994, which is a complement to RCRA and specifically addresses solid waste open dumping sites on tribal lands. The purpose of the Indian Lands Open Dump Act is to identify the location of open dumps, assess the relative health and environmental hazards posed by those sites, and provide financial and technical assistance to tribal governments to close open dumps in compliance with federal standards and regulations, specifically RCRA, as well as standards promulgated by tribal governments and Alaskan Native entities. It's important to note that sovereign immunity is not a defense to RCRA compliance. The Blue Lakes v. U.S. EPA case found that RCRA waives tribal sovereign immunity. Neither the state nor the federal government has authority to regulate solid waste on tribal trust lands. Therefore, if tribes do not have programs and laws to address solid waste within their boundaries, they could be subject to civil suit pursuant to RCRA if violations of the Act are found within those same boundaries. This is a serious issue with respect to open dumping that still occurs within tribal lands. An open dump is defined as an area where waste is dumped and left in the open, in contrast to municipal solid waste landfills, which are excavated areas where municipal solid waste is placed and then covered, appropriate to the Resource Conservation and Recovery Act's standards. There are many open dump sites on tribal lands that have been used for generations by community members to dump waste. Many of these locations are not landfills certified under Resource Conservation and Recovery Act and compliant with CFR 258. Unless a site where waste is dumped qualifies as a 40 CFR 258 or similarly permitted landfill, they are considered open dumps and are in violation of RCRA. Municipal solid landfills are excavated lined treatment areas for discharge of leachate, buffer zones, and waste that is covered daily to prevent odors, vectors, or additional contamination that could adversely affect the environment. The RCRA provisions regarding landfills play an important role in another case involving tribes and RCRA. In BAD v. EPA, the Campo Band of Kumeyaay Indians sought to develop their own permitting plan for solid waste facilities and landfill classifications, relying on the commonly used tribes as state standard in other environmental laws. Based on guidance from EPA, the Campos sought the tribes estate status under RCRA. In the BAD case, a local community group seeking to shut down the Campo Band's attempts to start their own landfill filed a suit against the tribe, arguing that they did not have authority to develop their own permitting plan under RCRA. The court did conclude that since they were defined as a municipality under the Resource Conservation and Recovery Act, the tribe was not authorized to operate solid waste permitting program. The court clarified that tribes are not prevented from operating solid waste management programs. creating and enforcing solid waste plans, or seeking site-specific regulation of landfill approval. The court found that the only difference between the Campo Band and a state with approved plans is that a landfill operating on the reservation must comply with 40 CFR 258 design standards, in addition to the operating standards. This case is often cited for confusion regarding a supposed solid waste loophole, which argues that because tribes are not given tribes estate status, there is a regulatory loophole for solid waste management in Indian country. However, there is not a significant regulatory gap within solid waste as a result of RCRA's municipality definition. The BAD versus EPA municipality definition in RCRA only limits tribal authority to use an equally effective alternative to RCRA's CFR 258 design standards. It does not otherwise substantially limit tribal authority to regulate solid waste within tribal lands. Serious policy issues related to the lack of the TAS or tribal estates status under RCRA, however, does not change tribal inherent authority to regulate. Blue Lakes provided that EPA does not have authority to regulate solid waste on tribal lands, nor do the states. So if tribes do not regulate solid waste on tribal lands, it leaves tribes vulnerable to citizen suits under RCRA.